wait for. Yeah.
That he's moving.
Okay.
Yeah.
All right. We're starting. I'm constituting this as the first session of the Web of Influence. This is no longer the conference. This is the Web of Influence in action, and the cartel and Web of Influence. I also want to join everyone in thanking Jerry, who's not here, but I'll thank him anyway. And thinking about this, I thought he's sort of like the conductor of an orchestra. This is like a bizarre orchestra of different instruments and different sounds. And in a way, Jerry has sat there sort of both composing for it and directing it. So I just want to thank him for that. And with that, I'll turn it over to the first panelist, Robert Evenson. I'm sitting here so I can enforce the time.
Okay, good, very good. Well, thank you. It is a great pleasure to be participating in an interesting and important conference. My topic is, if I can get this thing. Is agricultural research and essentially some of the distinctive features of agricultural research, one of which is that it has a very important public sector component to it. I'm describing things in 5 technological revolutions. I won't say much about some of them, but C, the crop genetic improvement revolution in the early part of the 20th century in the developed countries, and reflected in the green revolution in the developing countries in the second half of the 20th century is an important component. I'll also say a little bit about the gene revolution, the recombinant DNA, biotechnology work. I'll put a few remarks on science links, public-private balance, and role of intellectual property rights in history. But then I want to look at some innovation and imitation capital classes, and then finally say a few words about the implications of the TRIPS now. Okay. I want to use this as to introduce my topic, because I don't think it's quite appreciated. This is the price series, the index of farm prices paid to farmers for cereals and other products, divided by the index of all prices in the U.S. economy from 1775 to 2000. We see 50 years of about an even balance, productivity gains being about the same in the farm sector and in the other sector. 100 years of this ratio rising, which means that the productivity gains in the farm sector are somewhat slower than productivity gains in the rest of the economy. World War, and then during the 1930s, we saw the first introduction of genetic invention, genetic improvement, hybrid corn, a lot of other varieties and so forth. We saw the interruption of World War II, a spike in the OPEC years. But the feature for the last 50 years, even 70 years, is that agricultural prices have fallen to approximately 1/3 or to 40% of their level in 1950, relative to all other prices. This is backed up by the studies of Dale Jorgensen and others, essentially, which show in all OECD countries the agricultural sector outperforms the rest of the economy in TFP growth by about 1% per year. And you'll see that the Green Revolution essentially reinforced this greatly. Okay. Agricultural mechanization, the main point I want to make here is that farm size and equipment was very much driven. We know the long history of reapers, of McCormick reapers and so forth. 1862, the Homestead Act decided that the proper farm size for Midwest agriculture was 160 acres. And so this was the unit that was essentially made available to immigrants and to farmers who wanted to purchase the land and so forth. By today, with modern equipment in the Midwest, you essentially pull into a field in the spring, and in one day you plant, you prepare the land, you plant it, and you do it in just 160 acres. And if you're not prepared to do 160 acres a day, you don't have the right equipment. So the typical farm now is 10 times the size that it was in 1940. Asia, small farms, little change. Africa, medium size, moving to smaller farms. Latin America, medium size and increasing, showing somewhat the same patterns as the U.S. The chemical revolution, the main feature here is that insecticides were really not available until the 1960s and 1970s, herbicides even later. The big advance was the Helfer process for ammonium, which essentially lowered the cost of nitrogen fertilizer by approximately 1/3, or to 1/3 of what it was before the Helfer process. Again, transfer to developing countries, very limited herbicide transfer, some insecticide transfer. Intellectual property rights were important in all of this. Now, the Green Revolution basically is a public sector matter. The first patents available to plants, Michael Blakeney described these, the 1930 Plant Patent Act. But this is for asexually reproduced material, very minor effects. 1970 had some small effects. The Hibbard decision brought regular patents into the picture, and in the 1990s, a lot of biotech methods patents were. Agricultural experiment stations have dominated crop genetic improvement. These are almost all government, with some international centers. The International Agricultural Research Centers were built in the they started actually in the 1940s, but it was really established in the late 1960s, or during the 1960s. And they are truly public goods producers because they essentially had a mandate to produce public goods in the form of breeding lines and genetic materials that were delivered to national program breeders. They did not have a national commitment. They had international commitments, and they've been very successful. Modern variety production. It's often said that the Green Revolution was primarily in rice and wheat, and that it was over by the 1980s. That's not true at all. It was in many different crops. We're covering 11 in the study that we're doing. There are 8,000 varieties reflected in this chart, and they differ the rate at which the varieties were produced and released. All of these varieties were released by national release agencies, and each decade shows higher and higher releases. The important thing is the adoption of varieties, and you'll see a difference between the previous slide and this slide, in that sub-Saharan Africa adopted almost nothing in the 1960s and 1970s, even though varieties were released for them. Remember that the adoption and diffusion of varieties is a matter of what farmers find worth adopting, valuable. All of the international centers tried to produce technology that was friendly to the environment. They tried to produce technology that didn't use fertilizers and so forth. The farmers decided what to adopt. And it turned out that they were heavily, although we'll see a major difference in the, they were heavily in the, fertilizer using in some crops, but not in others. Some of the crops are suited to the Icrasat, the semi-arid tropics, are very harsh environments. Yet there's been sorghum and millets have been contributed there. And Acarda in Aleppo, Syria, has produced varietal improvements for the harshest environments of all, which are the dryland environments. So it's not true that the modern variety production process has been confined only to irrigated fertilizer using crops. This is a summary of growth rates in the early Green Revolution and in the late Green Revolution. 61 to 80 is the early period, 81 to 2000 in the late. And you can see that for Latin America, Asia, and the Middle East, North Africa, certainly in Asia, you had production growth rates in these crops, which are most of the crops, that were far in excess of population growth, except in sub-Saharan Africa, where population growth was 2.5%, you were far below. The early Green Revolution period was a period of disaster for Africa. The late Green Revolution period is a period of much slower growth, but it is still ahead of the population growth, which was around 2%. It's now fallen to about 1.5 or 6% in some of the Asian and other countries. Africa is still high, but we've seen a tremendous increase in the growth of production in Africa. And the interesting thing is that it is virtually all associated with area expansion. Very little, there has been some, and you can see that in sub-Saharan Africa, the modern variety contribution was almost nothing in the early Green Revolution. And in the late Green Revolution, it was less than it was it was about the same as it was in Latin America in the early Green Revolution. But the contribution of other inputs per hectare, fertilizer, irrigation, and so forth, the fact is that Africa has not had fertilizer accompanying the modern varieties that have been adopted. Furthermore, it seems that there's almost no scope left for advisory comments or advice to farmers to get them to produce better technology. A word on livestock industrialization, and again, one of the points I want to make here is that over the last century, we've seen, particularly livestock, has gone from being backyard to industrial. And it's driven very much, and so, for example, in the early 20th century, we had small backyard poultry, swine, small feedlots, and so forth. By the late 20th century, agricultural production in the United States is completely industrialized. All of the poultry is produced in confined animal system units. All of the swine, almost the milk production is in 10,000 cow herds and to a large extent today, and modern and large cattle feedlots. We once brought the cattle from the ranches in the Great Plains to the Corn Belt to feed them. Now we ship both the corn and the cattle to more desirable winter feeding ranges in Colorado, Texas, Oklahoma, and California, and some parts of the Southeast. It's driven in developing countries by supermarkets. One of the amazing things that has happened since 1990 is that in Asia, in 1990, 5% of the food was sold through supermarkets in Southeast Asia. Today it's 50%. And in South Asia, it's a little bit less than this. And what's really driving the developing countries is essentially the massive expansion of supermarkets and fast food chains. Kentucky Fried Chicken wants Kentucky Fried Chicken. And they're not going to buy these scrabbly backyard chickens. They're only suited to the wealthy who want range-fed chickens in in fancy restaurants. Okay. Recombinant DNA, we've already seen much of the issues here, and I won't say much more about it except to make some conclusions on the. One of the things that I have in my paper is an innovation capacity index. I've got country groupings. I'll show you some data from that. One of the main features here is that the presumption that the South is somehow uniform is completely at odds with reality. There are parts of the South that have had that are no different than they were a century ago, and there are parts of the South that are vastly different from which they were a century ago. So I have a little indicators system, and you'll note that in class 1 and 2, intellectual property rights, there's no really functioning intellectual property rights. They may have some laws, they may have some intellectual property rights, but they really don't have any real. and they don't have R&D in manufacturing firms. So this is something that it's a point that I want to stress in my in a later slide. Here are the country classifications. You'll see that Africa countries, these are for 3 periods, so when it says 111, that means that you started with class 1, which is the lowest possible class, which essentially means no capacity at all, and you stayed there for 3 periods. 112, you moved in the 3rd period. So I've got class 1, class 2 are those who started in 2s, and class 3 and class 4 in the slide you'll see in a moment. One point on inheritance. The British colonies in Asia inherited 2s and 3s. The British colonies in Africa inherited 1s and 2s. In fact, most of the British colonies in Asia were actually 3s at the beginning of the 60s. The French colonies in Africa inherited 1s mostly. The Belgian and Portuguese colonies inherited less than nothing. they literally had, they not only didn't inherit anything, they were actually disadvantaged from the start. They virtually had there were countries in Africa had 6 college graduates at independence. And so we need to bear that in mind when we think about how long does it take to go from a 1 to a 2 and 2 to a 3? 15 years minimum. So I'm going to come back to this slide in a minute. Economic indicators. Rural population density doesn't differ very much across the groups. There's group 1, 2, 3, and 4. Irrigated land, fertilizer consumption. If you'll see in Africa, group 1, 62 of the 100 grams, 6,200 grams per hectare. 40 times as much in group 4. Why? It's because the modern variety adoption in group 1 is less than 5% of the area. They did not get a green revolution. Cereal yields, 1 ton per hectare, almost 5 tons per hectare. In the Netherlands, fertilizer is 7,000 instead of 2,500. Yields are 6 tons. And the Dutch have an incredible insensitivity to, they essentially are scolding the Africans for too much fertilizer use. And they have 100 times as much fertilizer use in Holland as they have in Africa. There's no question that these things have. So, and agricultural productivity, okay. Indicators of total population, GDP per capita. We do have some GDP per capita in group 1. They do have slight growth, but it's a little bit hard. It's approximately 0. The maximum in group 2 is 1.9% per year. Their average is 1.1, 2.4%, 3.7%, and part of this is just plain industrial competition. So group 2 has had the green revolution. Group 1 has not had green revolution. Have any of them had any industrial competitiveness-led growth? This is the UNIDO Industrial Performance Index, and it essentially, the Group 1 countries have 0 competitiveness, and they haven't improved it at all. Group 2 countries have almost 0 competitiveness. It's a little bit, they're moving toward competitiveness. You have to be about 0.04 before the share of labor in agriculture changes, before you actually get in shifting engagement. So it's only the group 3 and 4 that essentially have competitive industries, and the group 4 have very competitive industries, given their wage rates and so forth. So the growth pattern that we observe here is a matter of the, oops. Okay, I'm sorry. I'm going to end here. Basically, for the developed countries, industrial property is entirely a matter of the gene revolution. Everything is being driven by the intellectual property rights associated with biotechnology. For the poor countries, one of the points I want to make here is that, when the British Patent Office was established in India in 1910, there wasn't any doubt as to what it was there for. It was there to protect the mother country. There was no question at all. Any benefits to India were incidental. TRIPS is a mother country enterprise. It is driven entirely, almost exclusively, by the interests of the rich countries. And any benefits to the poor countries are perceived by the poor countries as incidental, virtually. And I want to make this point. TRIPS is exactly like the British Patent Office in India, almost. Okay, there's flexibility, there's all of these issues and so forth. Is it any wonder that the Group 1 countries have no interest at all? They have no experience with and no interest at all in intellectual property rights. If they're going to actually have any property rights, they'll hire some lawyers to come and draft some laws for them, and that'll be fine. Group 2 don't have property rights, not functioning, and they're being pressured into them. Group 3 have property rights, and they're not quite sure whether they really want them. Group 4 have property rights, and they do want them. And so the diversity among developing countries across this range of countries is just incredible, ranging all the way from countries that have had massive improvement, high rates of growth, China, India, to countries that are no better off, that are poorer than they were at the beginning of the century. And the final point is that when it comes to traditional agriculture, which is often presented as some kind of a wonderful paradise, traditional agriculture in 1950 was probably suited to giving you per capita income of $2 a day. With those price declines that we saw in the graph, today you cannot make more than $1 a day per capita using traditional agricultural techniques. And at $1 a day, 30% of your children die.
Now we'll go to one of the mother countries, and Richard Nelson. And I'm reserving, if the Netherlands wants a point of privilege later on, they can respond.
The essay that I have presented to this conference, and what I'll talk about this afternoon, is not oriented toward the North-South problem or TRIPS at all, though that arena may be where a lot of my research over the next year or so will be going. Rather, I am focused quite directly on what is going on in the United States and in the other technological frontier countries of the world. And my point of view is that what is happening on the intellectual property rights front is very likely to be increasingly counterproductive regarding the facilitation of technical change. Given what I understand others have been using their time to talk about, I suspect that the most useful contribution I can make here and now is to talk about the processes of technological advance and to highlight the critical role that the scientific and technological commons plays in those processes. So while the essay in your folder covers a lot more terrain than that, this is where I'm going to focus my attention here and now. I think, Bob, it'd be fair to say that every serious scholar of technical change who's looked at the empirical details uh, understands that the process is an evolutionary one uh, in the following broad sense of the term. That in any area where you see significant advance, at any time you will also see a variety of efforts to advance the technology going on in competition with each other and with the status quo. And the winners and losers in this competitive process are determined to a very considerable extent in ex post selection. That virtually every attempt that has been made, either by broad technology forecasters or by those in charge of planning research and development at companies, to predict in any close-grained way just what advances in technology are going to be coming over the next several years that will be the winners, have been doomed to failure. This is very, very much an experimental process in which an awful lot of what happens is learning by doing and using. But on the other hand, in saying this is not to deny the extremely central role of human purpose, of strategy, and in particular of the tremendous knowledge and technique that are brought to efforts to advance the art in a technological area. The body of knowledge and technique that individuals and organizations bring to their efforts to improve the technology, first of all, provide very much of a focus on what are the promising leads and avenues to explore, and which ones are going to be with high probability the dead ends. The knowledge and technique brought to the task provides a whole array of problem-solving skills to the endeavor as the efforts go forward and particular problems are met in the course of the effort. And to a very considerable extent, what the knowledge and technique bring to an inventive effort is an ability to test, an ability to identify whether you're on a good path or not. The testing ability can range from things like pilot plants in chemical product and process development to simulation models to ways of testing materials to make an assessment of how long they're likely to last and hold up under the stress that the final product is going to go through. And it is this knowledge and technique that give power to efforts to advance a technology. And if Bob were to deliberate a little bit on changes over time in the nature of agricultural research, what you've seen is progressive advances in the body of scientific understanding that has lent more and more power to that particular effort. So the proposition that technical advance is an evolutionary process in no way denies the extremely important role that scientific knowledge plays in the modern endeavor. On the other hand, it is just absolutely clear if you study the history of technical advance in the area that contrary to predictions that have been made by scientists and economists for over a century, that what the strength of ever-improving science will do for you is to significantly improve the ability to plan and predict in detail the process of technical change. It's clear that really has not happened. And rapid, effective technical advance continues to require competition and a variety of participants in the process, exploring a variety of different avenues for going forward. On the other hand, it has become increasingly so over the years from the early 19th century up until the present, that effective participation in the process here requires access to that basic body of knowledge and technique that enable you to identify paths, to solve problems, and to do the testing short of full-scale commitment to a particular design. And therefore, to go back to the theme that I introduced at the start, there is a basic commons of knowledge and technique that is absolutely essential these days to being able to have a structure of inventive activity in a field in which a large number of participants can engage. This shows up both the need for the pluralism and the competition, and the essential role of the access to a common, sophisticated body of understanding and technique in study after study after study, from Ed Constant's wonderful history of the development of the turbojet engine in aircraft, where what is so striking is the number of different engineers and companies who were engaged in the process and made different kinds of contributions to it, and at the same time, the common body of knowledge and understanding that was shared by all sophisticated people and companies working in the field. It shows up in the history of the development of medical know-how, strikingly so in that wonderful book by Roy Porter on the greatest benefit to mankind, which details many areas of medical advance. What is striking about virtually all of them is the number of different people and organizations that are involved in a continuing successful effort, and how much shared knowledge and information there was in driving the process. It is strikingly clear that by the middle of the 20th century, the bulk of the generic knowledge and technique that people and organizations needed in order to work effectively in an area of technology was contained in the applied sciences and engineering disciplines that had risen up in the last part of the 19th and throughout the 20th century. And this, of course, was reflected in the extent to which the inventors and creators of new technologies increasingly became university-trained people, and in many fields, people with PhD training in a particular area of science. And I am highlighting here the importance of that key common scientific base, which I think has been neglected in much of the discussion by my colleagues in economics, not Bob, regarding the factors that generate rapid technical progress in a field. In virtually any field that I know about that has moved rapidly over the years, what one has is a basic, strong, shared scientific and technical commons, and on top of that, at any time, a relatively thin layer of relatively specific proprietary technology, which in a number of industries is an important driver and inducer of efforts to advance the technology, but always the efforts there are based on what has been going on in the commons. Modern societies, those that essentially have shared in the technical progress that has been achieved over the last 100 and 150 years, have developed a wide set of institutions to support the commons, as well as to support the proprietary aspect of the process of technical change. Sociologists of science like Robert Merton have articulated extremely well the value of the commons that up until recently at least used to be deeply imbued within the community of scholars who were involved in the basic sciences. But for the most part, the Merton orientation is to fields like physics or to theoretical chemistry, and that is where most of his examples are drawn from. But that same tradition of contributing to a scientific and intellectual commons also traditionally has applied very strongly in the applied science, scientific and engineering disciplines that I have been describing, and which play such an important role under most technologies. You can see that, for example, in various studies of the rise of aeronautical or chemical engineering, and the importance of that professional community, training new people entering the field, and sharing generic knowledge with each other in conferences and through publications and matters, vehicles of that sort. And it also is prominently so in the whole area of medicine and health. The universities have in these applied science and engineering disciplines been traditionally the custodian of the advanced training and of the open research in these fields. Now, what I think is concerning me and concerning a number of other people who are here is that over the last 20 or 25 years or so, what one has seen is the beginning of an erosion of the general scientific and technological commons in a number of different fields. And our proposition is that the growing proprietization of areas of technology can be very costly to society, not simply, as in the old standard models in economics, in cutting down on the extent to which there is competition in the production and use of particular products or processes. But to the extent that what happens is that the intellectual property rights is going down into the body of material which have major uses in the research process itself. In the process of advancing the technology, the encroachment of intellectual property rights into those areas can be completely counterproductive relative to the articulated purpose of the intellectual property rights system, in the sense that it can slow down and make much, much more costly and difficult the process of technical advance itself. This is a matter that has concerned me a lot, and there are two broad areas to reflect on here, both of them having to do with, in a sense, the design of an intellectual property rights system and the acceptance of various roles in this broad system of advancing technologies that different institutions take on. There are major issues with respect to how far upstream into the research process intellectual property rights ought to be granted. And there are very major issues regarding the scope of the intellectual property rights that are given on a particular breakthrough, which is a member of a relatively roomy class. How far into the class that should go. There are also major issues, it seems to me, with respect to university policies. For many, many years, up into around 20 years ago, I think it is fair to say that the principal supporters of the notion of a scientific commons in the applied science as well as the basic ones was the academic scientific community. And one of the striking things that Boyle has done has been to significantly erode the extent to which universities and university scientists have become custodians and supporters of the intellectual commons, which is a matter that worries me, and I think worries a number of other people. As I reflect on this, the words of Pogo come back to me, and that is, I have met the enemy and he is us.
Our next speaker is Ruth Okediji from the University of Minnesota.
I'd like to thank Jerry and Keith for planning this conference and for inviting me to participate. I think that my job this afternoon is to do a couple of things, and I'm hopefully going to wrap those up in a way that makes sense and gives us something new to talk about as well. When I was growing up, I discovered that I had a grandfather who had 3 wives. And I said to Mom, why does your dad have 3 wives? And she said, I asked the same, why does your dad have 3 wives? And she said, I asked the same question, and I was told, how else would he run the farm? And I think that a lot of my own thoughts on the proliferation of intellectual property rights and the expansion of copyright in particular has raised, or at least given me, the same response from industry, and that is, how else would we run the farm? How else would we make money? So my task today is to consider the problem of access to digital works in light of the WIPO digital treaties, which are now in force in about 41 countries to regulate the impact of information technologies on the creation, use, and distribution of works of authorship. So I'm going to shift gears from what the two preceding speakers focused on. Now, there are a lot of people in the audience, at least Pam and Jerry, who are both far more intimately aware of the development and negotiations leading to the conclusion of these treaties. Pam's work in particular has chronicled very nicely the U.S. agenda that was blunted by a winning coalition of public interest groups and developing countries. We've heard a little bit about this throughout the course of this conference. But it was this coalition that succeeded in inserting what we now think of as access mechanisms into the final text of the treaties. And as concluded, the treaties preserve the right of countries to provide exceptions and limitations to the rights granted therein. But of principal interest for my purposes is, of course, the rights contained in Articles 11 and 12, and I'm going to focus on the copyright treaty. Article 11 requires contracting parties to provide adequate legal protection and effective legal remedies against the circumvention of effective technological measures used by authors in connection with the exercise of their rights, both under the Copyright Treaty and under the Berne Convention. Further, Article 11 requires that contracting parties provide, again, adequate legal protection and effective legal remedies against circumvention efforts directed at technological measures used by authors to restrict acts that are not authorized by those authors or permitted by law. And then, of course, Article 12 talks about rights management information and requires parties to the treaty to provide adequate and effective legal remedies against those who know or have reason to know that removal or alteration of rights management information, distribution, importation, or broadcast of the same work without authorization would be a violation of rights under the treaty. And so these two provisions of the WCT are, of course, what have justified in the U.S. Under the notorious DMCA, both the anti-device and the anti-circumvention provisions. Now, as many others have pointed out, nothing in the treaty itself requires this narrow, highly protectionistic, and inflexible incarnations of Article 11 and 12 that both the U.S. and some other developed countries have enacted, and which they now seek to entrench in bilateral agreements as the model for implementation of the WIPO Copyright Treaty. Most notably, I guess, about the domestic implementation in the U.S. and other developed countries is that the important access mechanisms such as fair use have been gutted in most of the versions that we are now seeing implemented in the bilateral agreements. And the uses which would have very easily been described as fair use now appear as concessions that have had to be wrestled from the hands of reluctant owners. And so, as it were, rather than fair use being a robust privilege or exception to the copyright right, they are now listed as narrow exceptions to owners' rights. Why is this so important? As others have noted, the rise of bilateral and multilateral regional agreements between the U.S. and the EU primarily and developing countries seeks to entrench these narrow interpretations of the provisions of both treaties as the reigning normative or even doctrinal mode of implementation in domestic legal systems of the developing countries. Although both the WIPO treaties identify or at least state that they are independent treaties, in fact, in the world of public international law, that's a little bit naive and superficial. Why? Because in at least one instance with Professor Reichman has noted, I think, repeatedly in some of his recent work, in the process of interpreting the TRIPS agreement, at the very least in the context of dispute settlement, these subsequent multilateral and bilateral agreements represent some form of state practice, some sort of customary international law that in theory at least, could be looked at by panels in interpreting the scope of the TRIPS provision itself. So the notion that the WIPO copyright treaty or any subsequent treaty that builds on TRIPS or that is subsequent to TRIPS is somehow a standalone treaty that will have no reverberating effect with the TRIPS mechanism is certainly misleading at the very best. In some other work of mine, I've identified what I call three genres of access mechanisms evident in the Berne Convention and incorporated in the TRIPS agreement. First, we have the general principle of access in Article 9.2 of the Berne Convention, which is limited to the right of reproduction. It allows countries to provide for limitations or exceptions to the right of reproduction. As a second genre, we have a series of enumerated limitations throughout the Berne Agreement, which are also incorporated into the TRIPS agreement, such as Article 2 bis, 10 bis, et cetera, that really are directed at specific kinds of uses. And we also see this, of course, in the US copyright law, where we've got the broad fair use principle, and then we have a series of enumerated rights littered throughout the Act. As a third genre, I identified limitations possible through the use of legal instruments such as compulsory licenses or internal mechanisms such as the doctrine of exhaustion. And as I said earlier, all of these three different genres are incorporated explicitly in the TRIPS agreement or by a process of interpretation through customary international law. And we certainly see the Berne three-step test being applied or at least examined for the first time in an international forum in the Section 110.5 case. And in that case, the nuanced provisions of TRIPS Article 13 gave rise to an interpretation that maintained the principle of less than complete ownership of creative expression. The WTO panel in that decision ruled that Article 13 is not limited to the new rights granted under TRIPS and is also potentially applicable to all copyright rights, as opposed to Berne Article 9.2, which, as I said earlier, is limited to the reproduction right. Despite this important acknowledgement by the WTO panel, I would still say that access mechanisms under international copyright treaties remain less than satisfactory and certainly don't rise sufficiently to the level of being able to properly preserve the cultural commons. As with the case that we saw and certainly talked about a little bit yesterday with limitations to patents, copyright exceptions and limitations have no strong normative principle of consistent international application. Now, Neil Netnell has talked about an international freedom of speech standard that fair use ought to support, and that WTO panels might be influenced by this to give a more expansive deference to national norms that support fair use. But really, even the notion of an international First Amendment right is, at best, questionable, certainly not First Amendment in the sense in which the U.S. jurisprudence would have it. The discretion granted to national governments to utilize exceptions and define them in national laws has, in my view, been very problematic. They've been problematic because, as Bob Cohane mentioned yesterday, it is this precise deference mechanism that has created the opportunity for bilateral and regional agreements to lock in developing countries to particular articulations of the scope of proprietary rights. So whatever you get at the multilateral level, say at TRIPS WTO, you end up ultimately losing at the regional or bilateral level because they create opportunities for side payments, as Bob Cohane mentioned yesterday. So these discretion that we give or that we succeed in obtaining in international fora become bartering chips in the bilateral context and lock in hardened, not soft norms, but hardened norms in the developing countries that are affected by those bilateral agreements. Most importantly, however, in my opinion, is the point that the access mechanisms that the three genres that I identified so far have been acceptable to public interest groups in developed countries as well as to developing countries, but I would argue that they fail the test of what, as I titled my paper, sustainable access. The existing genres of access rules permit use on an ad hoc limited basis. They're almost sort of like the compulsory licensing provisions we talked about in the context access to essential medicines. You have to have some justification. Typically, it's got to be a narrow justification, some urgent need that justifies the utility and the invocation of these access rules. There is no consistent dynamic of welfare enhancing norms that might crystallize ultimately in an ethos of access for public interest uses. Thus, I would advocate that what we need to think about are not just things like fair use exceptions and enumerated rights for users, either for First Amendment principles or for research or for private use, but a more dynamic notion of sustainable access, which consists of, at least in my mind, in my thinking so far, the following suggested elements. Number one, I would suggest a clear international norm of access. A clear rule that talks about, as opposed to a standard, that talks about the value of access. Now, in the TRIPS agreement, we see this a little bit in the preamble, but it's not articulated enough to give us a sort of dynamic movement towards sustainable access to digital content, and for that matter, print content. Secondly, I would suggest that sustainable access requires alternative models of creation and distribution, the legitimizing of those models and the opportunity to implement those models, perhaps as alternatives to copyright, and I'll come back to that in a few minutes. Third, a principle of sustainable access would continue the tradition of ad hoc rules. I think the ad hoc rules are good. I think we need them, and I think we should keep them since we already have them. I'm simply advocating for something a little bit more significant and a little bit more robust. Fourth, I would argue, and this is perhaps something that I am very heartfelt about, that the paradigm with which we have looked at access mechanisms in international copyright law in particular has been very impoverished. Larry Helfer, I think, mentioned this first, and Graham and I had a conversation about this earlier this year as well, that one of the fundamental things is that we need a paradigm change. TRIPS gives us minimalist rights, which countries can improve upon, and maximalist access rights, which countries cannot improve on. This has been the paradigm of international copyright law. We give you these minimum rules for owners, and you can certainly give owners a lot more if you choose to, country by country. But we're going to give you these maximalist use rights, which you can't improve upon, which you can't expand upon. And I would argue that that model needs to be flipped. In my perfect world, I'd like to see maximalist rights and minimalist access rights. In my less perfect world, I don't mind splitting, not the baby, but something else in half, right? I don't mind saying, let's have minimalist owners' rights and minimalist use rights that countries can also improve upon simultaneously. And so we at least have some balance there. But I think that if we change that paradigm, we will allow the use of dispute settlement to raise access levels rather than to defend them. And that, I think, is, again, as from a strategic point, something that our current paradigm does not allow. Every time we have an opportunity to expand fair use or to do something other than give absolute clear property rights to content owners, we are reminded that this will be a violation of our international obligations. So that international obligations have now become the shield and the sword with which the preservation of the cultural commons is being undermined. I think also flipping the paradigm so that we have minimalist rights and minimalist owners' rights and minimalist access rights makes it more difficult to undermine access in subsequent treaties. Now, as I said earlier, why is this the case? Well, the digital treaties state that they're independent from TRIPS, even though that's not what it says explicitly. It simply says we're independent from all other international agreements other than the Berne Convention. And as I also mentioned earlier, this is just not true as a matter of international law. The Vienna Convention on the Law of Treaties requires that for all treaties that a country enters into, those treaties must be applied consistently. The principle of pacta sunt servanda requires that a country who signs both the TRIPS agreement and the digital treaties and any other subsequent treaty does so with some model, with some structure for how there will be consistent implementation in the domestic setting. Now, despite the WCT in Article 1, the pronouncement that this is an independent treaty, it is, I think, clear to me, at least, even though I wasn't at the negotiations for the digital treaties, that the WCT and the WPPT are clearly meant to benefit from the structure of the TRIPS agreement, particularly with regards to the enforcement mechanisms. Otherwise, these treaties would really simply be like the Berne Convention or like the Paris Convention. We would simply be reintroducing some of the inefficiencies and some of the enforcement problems that we had prior to TRIPS. It is because of the principle of pacta sunt servanda, the requirement under the Vienna Convention that international treaties be respected and honored and implemented by signatories, that the digital treaties will benefit from the enforcement requirements under the TRIPS agreement. If that's true, as a matter of public international law, then with regard to the requirements under Article 11 and 12 to provide effective legal remedies and effective protection of digital content, I would suggest that implementation of the TRIPS enforcement mechanisms and procedures is at least sufficient to satisfy those requirements. But that's not the only thing, right? There's also the requirement in the digital treaties that we apply the existing limitations in domestic law. So I would then argue that to the extent that the Vienna Convention exerts pressure on countries to coordinate and make their international obligations consistent with each other, implementation of the WCT arguably must also consider and include sustainable access rules. That we cannot just take the baby and leave the bathwater in this regard. However, access rules alone may not be sufficient to establish the regime of sustainable access that I am arguing for. As I noted earlier, there must be other means of encouraging creativity. And for this, what I suggest to do in the paper that I've not yet written is to look at how business models in the digital rights management movement, and the synergies provided by technology provide an opportunity to explore the prospects of alternative modes of creation and alternative modes of dissemination. Now, there are a couple of examples that we're all fairly familiar with. One, of course, is the model that says authors could perhaps dedicate their works to the public, and then support or generate revenues through the production of ancillary products and so forth. That's one that's been around for a while. It's, in essence, Peter Drahosch's point made yesterday about the commons. You give things for free, but there are other ways of supporting or generating this revenue. There's, of course, also the pervasive recommendation about a pay-per-use system, another form, essentially, of price discrimination. But then there's also patronage models where copyright privileges, as Paul David's opening paper yesterday intimated, copyright privileges could be privately auctioned. And of course, there's outright sale, but there would be no associated derivative work rights with that sale, so that members of the public could essentially build on that work for free. Now, we've heard today, I think quite rightly, that developing countries are not similarly situated, and that there will be a need for access mechanisms that may or ought to take into account the differences between developing countries. And in my more practical moment, it occurred to me that we're going to need to have sustainable access mechanisms in both print and digital works. So what I would advocate then is a hybrid model that utilizes, as I said, some of the suggestions that or that would hijack some of the suggestions made in the context of the digital rights management movement, and see how that might be used successfully for print and digital works to enhance dissemination. Our task, of course, is to imagine these rules and models that will preserve the sustainability of these mechanisms as much as the works of authorship. One of the things that I'm playing with right now is the concept of internet libraries that would parallel the circulating libraries of the 18th century in Europe, given the rise of literacy. My time is up, and I didn't have time to expand on some of these ideas. They will be in the paper, but I think it's important to note that against the backdrop of the structure of international law and the strategy of successive treaty making, sort of like serial monogamy or something, is the broader question of capacity. And I don't want to sit down without mentioning this, that as much as we can construct models and enact or articulate norms of access in order to preserve the cultural commons, that there's going to be a continued need for capacity building. If you look at the 18th century movement in literature, one of the problems why copyright was perhaps not as important and why alternative models came up in the 16th and 17th centuries was a low rate of literacy. We're having that problem here in the United States, but it's certainly compounded in developing countries. Terribly low rates of literacy mean that no matter how much we actually disseminate cultural goods, there is a problem of access. And that's a much more fundamental access problem than just whether or not the copyright raises the price beyond the reach of the masses. Secondly, there is structural capacity, and by that I mean electricity. You can't access digital works if you don't have electricity to turn on the computer. Of course, there are other structural capacity needs, like just owning a computer in the first place, which is where the Internet Library comes into play. And then there are the supporting institutions. If people can't afford $30 for antiretroviral ARVs, or other essential medicines, I'm not sure that they're going to be paying 7 cents per page of Stephen King's latest novel. And then finally, there are the educational institutions that need to be strengthened in order to make access meaningful, not only because the works are available at a sustainable price, but because the people and the institutions are there to absorb them. Thank you.
Our next commenter is Jamie Love, who I think organized last year's Boyle. I'm sorry.
Jamie Love,
I
much more
confused them. What can I say? But okay, Jamie Boyle. God, I've only got one duty as chair, and it's to get the name of the person right.
In the future, everyone will be called Jamie, and all of you will work at Duke, although we're actually making a substantial start on that this year. And I'd like to welcome you to Duke and to thank Jerry Reichman and also Jennifer Jenkins for putting on this fabulous conference, which we, his colleagues, are internalizing without having contributed to. One of the ways in which Jerry managed to squeeze so much wonderful content into this conference is to have a series of people who are labeled commentators but are in fact crypto paper presenters. I am such a person, and I want to say right now that he told me to do it. So I'm pleading superior orders. This is not a matter of me going off on a frolic of my own. I was told to do this, and I was brought up better, but what can I do? I want to continue the copyright theme, and I want to start, since I have only 7 minutes, start by a broad assertion, which I hope you'll agree with, which is that access to, in the sort of rich ways that Ruth described, access to copyrighted materials is going to be vital to any sustained idea of development. It's going to be vital to any sustained notion of participation in the creation of a common culture, of local culture, of global culture. Copyright is vital there. It is not simply patent. In terms of intellectual property rights that we need to focus, whether one's talking about literacy, whether one's talking about teaching, whether one's talking about training people in agronomy or calculus, copyrighted materials are going to be absolutely vital. And I'm simply going to assert that, although I'd be happy, I doubt we'll have questions, but if we had questions, I would be happy to defend that proposition. Let me start then, for those of you who work on patents principally and who do international development economics and who focus on the question of patent law, and to get you to focus on one of the truly strange aspects of copyright looked at from a patent point of view. Patent economists, it seems to me, have recently particularly enriched our knowledge by focusing, as Professor Nelson pointed out, on the neglected role of the commons in creation, have stressed frequently that there are costs to intellectual property rights, both in terms of straightforward static losses because of higher prices, but also dynamic costs because of possible restraints on future innovation, which may or may not be cured partially if you're a great licensing optimist, but which certainly introduce some level of drag. So there are debates, and I think those debates probably divide people in this room, about whether or not patent strikes the balance right, whether or not new rights complicate it, how the international system complicates it. Fine. Imagine the following system, those of you who are, so to speak, copyright innocents, copyright naives. Imagine the following intellectual property right system, an intellectual property right that you can get by accident. Right? Now, this is not, when you start thinking about patents, you don't normally think of, oh, a patent, I got a patent by accident. What a shame. An intellectual property right that can last for 150 years. Those of you who are thinking in what seems to me this delightfully short patent term, may sort of say, this hugely long right. An intellectual property rights system that has responded to an unparalleled expansion in the number of people producing expressive works that may be viewed, consumed, altered, and transformed by others in doing the following things: making the law much, much more complicated. It was questionable whether those new users, these people who are not publishers, not traditional magazine producers, not old-fashioned recording industry executives, but bloggers, teachers in high schools putting up their calculus page, people trying to explain local history, someone who's trying to develop a vocabulary or a primer for a language which is losing ground. These people who would have found it hard to understand pre-1976 copyright, well, we've thoughtfully made it much, much more complicated for them so that it's now extremely difficult to do so. So that all of you who are taking notes, of course, are producing copyrighted works. You don't need to put the little C on there. Jessica Littman, in a wonderful paper in the conference we had here last year, pointed out that about 30 years ago, at least in the United States, 99% of all expressive works potentially subject to copyright went immediately into the public domain. And all of us went, wait, the public domain? We sort of thought about it. And of course, simply by failing to comply with the formalities, it used to be, and of course the differences vary from country to country, it used to be that work would go into the public domain. So if those of you who's economists, imagine a system where you can get a relatively strong monopoly right by accident, without asking for it, which is defended by strict liability penalties, and to make it more fun, we now apply this regime, which is complicated by a series of, from my point of view, relatively strange both expansions and interpretations. We apply this to a group of people who are not repeat players, who do not understand the system well, and who are attempting, on the internet in particular, to build works in which they draw from other people's creative expression and try and put it together to create their own, whether it's someone putting together a class on calculus or agronomy, someone trying to put together a film, someone trying to put together sounds. We have this system. Now, it's hard to imagine, I have to say, an economist coming up with such a system, right? We'll give you the right by accident, We'll give you the right without asking for it. We'll give you a right even when you don't want it, and then when you ask the Copyright Office, how do you actually put stuff in the public domain? They said, and this is a quote, "We don't provide that service. Get creative."
That's great.
Now, here is the point that I'm trying to make. If copyright was largely a form of horizontal industry regulation in which repeat players, well advised by clever lawyers, dealt with a standard set of problems, then the kind of rules we've got might be defensible, although I actually personally think they wouldn't be. But one could argue that. Certainly the term wouldn't be defensible. However, given the groups of people who are both producing expressive works and, if we're thinking about international development, consuming them and we hope reproducing them and adding to them, they are completely indefensible. Okay. Again, I have to jump because I have little time. Wayne, could you bring up the webpage? What's to be done? One of the thoughts, could you click the choose one, Wayne, for me? Thanks. One of the things that, one of the points I'd like to make here is that while patent scholarship on development has been highly attentive to the possible drags that patent has introduced onto the possibility of future innovation, I would claim that the copyright debate, at least in terms of the legislative debate, and often in terms of the public debate, has been highly attentive to the dangers and costs from piracy, from illicit copying. We hear almost nothing about the costs from failed sharing. Your inability actually to use something because you're not sure of its legal status. Imagine that you want to put together some course materials. You think you can draw on this. The stuff's up on the internet. Obviously, They wanted me to read it. Maybe they didn't want to allow me to deep link to it. I think they allowed me to print for it. Can I excerpt from it? Can I create a derivative work? You simply have no idea, and frequently there's no easy way to find out. Second point, when you actually go to people, because of the current stories circulating in the press about the dangers of violating copyright, their immediate reaction is paranoia. I was writing an article which quoted an 18th century poem about a goose being taken off the common. And in order to track down the attribution of this, my research assistant contacted 15 people who had that poem dating from the 18th century up on their pages, and they gave wildly varying attributions and dates and so forth. And we were saying, can you just give us a little bit more about our sources, because we're trying to track this down. 10 of them immediately removed it from the web and wrote us letters of apology. 3 of them called up and said the people responsible for putting it up there would be disciplined. Now, this is anecdata to be sure, but particularly when one thinks of the poem is, the law locks up the man or woman that steals the goose from off the common, but leaves the greater villain loose that steals the common from under the goose. So you have an 18th century poem about propertization, which is oh no, take it out, very sorry, and the people responsible have been disciplined. Now, my point here is these rules, the rules we have, default copyright, copyright without formalities, automatic copyright without requirement of payment or renewal, are when one thinks, and this is a very narrow class of things perhaps, when one thinks of the possibility of using the web in order to generate, particularly in other countries, materials which draw on multitudes of copyrightable sources, this is a huge deadweight loss. What can be done? This is very much a second best solution, but together with a number of other people, most notably Larry Lessig, I was one of the founders and board members on Creative Commons. Creative Commons attempts to offer you licenses which have 3 characteristics. They're lawyer readable in the sense that they actually attempt at least to offer extremely good licenses to people who want to put exactly the terms they choose on their copyrighted work so that they can make them available without the default rules of copyright, leaving us to assume that no uses beyond, let's say, perhaps reading it on the web is permitted. So you see there, for example, Wayne, could you click require attribution? Yes. Yep. No for commercial uses. Great. And allow modifications? Yes, as long as others share alike. Click that. Okay, select a license. The second thing is that they attempt to provide something that is human readable, not just lawyer readable, so that the commons deed, which you would actually get, click learn how to apply the license at the bottom, has these various qualities to them, which actually gives you, click on the little green tag, some rights reserved there, Creative Commons license. This actually gives you an embedded piece which expresses in ways that we hope people will understand, which indicate how the work may use. But it's not merely human readable, it also provides metadata which can be attached to the work, which is attached to the work, so that we hope in a year's time you'll be able to search through Google for the copyright characteristics for the work as well as the content characteristics of the work. Give me all calculus tutorials that are available for unlimited non-commercial use with attribution, and derivative works are allowed. Very briefly, my conclusion. I've tried to say a little bit about maybe what copyright law could learn from patent law's attentive focus on the importance of having the barrier to the rights be high, thinking carefully about when you give rights, thinking about the potential costs for failed sharing as well as the potential cost for illicit copying. What could this teach patent people? I think that it might help in our thinking about international development and intellectual property rights by helping to reconstruct the commons, the scientific commons, which Professor Nelson spoke about so eloquently and which Jerry Reichman and Paul Uhlir have written about in particularly fascinating detail. It might help by offering us the possibility of similar types of licenses, which will offer us a second best solution that might mitigate some of the negative rigors which some of us here believe attend recent expansions of intellectual property rights. It's not a first best solution. First best solution would be not to have those rules developed in quite the way they have been in the first place. But it might allow, and this is something which Jerry and Paul have developed at some length, it might allow us, to use the line from their article, to think about the possibility of a contractually reconstructed commons, and hopefully one which was actually something that people understood and where the immediate response to, oh, where did that come from, was not, I'm terribly sorry, and all the relevant people have been fired. Thank you very much.
Thank you, and we'll conclude this section with Laurence Helfer.
Well, first I should thank Jerry very much for inviting me to what's been and continues to be a really wonderful conference. And also, following Jamie's lead, I'm going to take Jerry also at his word, and my comment will be a non-comment, but I do promise that it will echo the themes of the panel, the scientific and cultural commons, and the broader theme of the global commons generally. And I was really struck by Ruth's discussion about the narrowing of access and her proposal for new international norms of sustainable access. And I want to talk about that idea, but in a very different context. And it's in the context of a new international agreement that creates novel institutions and procedures for preserving the global commons for plant genetic resources, or PGRs for short. And one of the most striking features of this new treaty is that it, in fact, uses IPRs, or tries to use IPRs, as a tool to fund initiatives to preserve and protect the public domain plant genetic materials. So what I hope to do in just my few minutes today is to describe for you some of these novel institutional mechanisms and then explore just a bit their implications for the global plant genetic commons and the relationship between that and intellectual property rights. So that's really what I'll be focusing on. And before I turn to some of the mechanics, I think it's important just to step back for a second to think about why it is that plant genetic resources and their regulation has been a crucible for sustained global conflict. And I think there are really two reasons for that. One is that the genetic diversity of the world is divided unevenly among nations, and it's been dwindling at a pretty alarming rate over the last few decades. And these two forces have started to generate conflicting strategies for preserving and utilizing plant genetic resources. And dominating that debate is a line drawing or a boundary question, which is over where to delineate those biological materials that have to remain in the public domain from those that can be privatized through the grant of IPRs. Now, the debate over where to fix this boundary really isn't a new one. It dates back more than 20 years to a document known as the International Undertaking on Plant Genetic Resources, which was a declaration which stated that all PGRs, including, interestingly enough, plant-related innovations, were part of the common heritage of mankind, the common heritage of humanity. Now, this undertaking was only a non-binding statement of principles, but even in that form, it was considered a threat by the United States and by some European governments who began to water it down and weaken it over time. And faced with what began to seem like increasing private control over PGRs, those seeking to defend the global genetic commons began to develop, or try to develop, legally binding rules to delineate a clear line between proprietary and public domain plant genetic resources. And they also wanted to reconcile some of the intellectual property, national law developments, and international agreements that Michael Blakeney spoke about this morning. And the result is this new treaty, which was adopted in November 2001, and I'll talk about a couple of its institutional features. The most noteworthy one is the creation of a mechanism to promote the conservation and exchange of seeds and other plant genetic materials, which are the raw materials for plant breeding and innovation in agrobiotechnology. Now, how does the new treaty do this? Well, specifically, it creates what's called a new multilateral system to which member states and their nationals get what's called facilitated access. Now, what is the multilateral system? Well, in essence, it's a kind of a limited common property composed of a selection of 64 food and feed crops which cover most but not all of human nutrition. And in exchange for access to what you might call this communal seed treasury, those which are mostly, by the way, held in government and international seed banks, private parties who create commercial products that incorporate materials from the system must pay a percentage of their profits into a trust account, the funds of which will be used to promote benefit sharing and conservation of PGRs, especially in developing countries. Okay, so that's the novel institutional feature, and the states were able to reach consensus on the broad architecture of this new seed treaty, but they differed sharply over IPRs. And the core of the debate focused on whether it would be possible to bar patenting of isolated and purified genes that had been extracted from a seed that had been placed in the common seed pool. And at the final round of heated negotiations, the delegates adopted a key clause, which will be one of my only 2 PowerPoint slides, assuming, let me go back. There it is, right? This is Article 12.3d, which states that access to entities such as plant breeders, commercial plant breeders, and others will only be provided on condition that recipients shall not claim any intellectual property or other rights that limit the facilitated access to the PGRs for food and agriculture or their genetic parts or components in the form received from the multilateral system. Now, if you think about this text, as I have, and you read it sort of for too long, you start kind of losing what clause reflects to the other and what it really means. And eventually I sort of decided it didn't make much sense until I really thought about what the last round of negotiating history was with respect to this clause. And what exactly existed was that at the final round of negotiations, there were 2 distinct clauses, which I've highlighted in brackets at the end of the article. And these were bracketed text going into the last round of bargaining over the treaty. And it was the developing states that opposed patent protection, which sought to retain the first clause and delete the second, whereas the U.S. wanted to the first phrase deleted and the second retained. So what did the delegates do as a compromise? They retained both, right? And so the result is a very sort of cryptic text. And you might think, okay, what's the political economy behind this, right? This language. Well, I think there's sort of 3 sort of possible things. One was a concern that NGOs had raised and that Michael Blakeney discussed briefly this morning about what had been going on with the patenting or plant variety protection of materials that had been taken directly from international seed banks. And so that was one significant concern. A second concern was for developing countries wanting a sort of different forum to limit patent protection. And a third and final concern was plant breeders who really did want to preserve access to raw genetic materials. So what we're left with is the critical interpretive question of just how far a seed's genetic blueprint has to be modified so that the resulting material is no longer, quote, in the form received from the multilateral system. And views are divided on that, and I'll just say, echoing a point that Ruth mentioned about states creating practice through subsequent treaties, they also create or try to create Article 31 practice under the Vienna Convention by entering interpretive statements on the record, which Canada, the US, the EU did, saying, well, nothing in this language is going to conflict with our own intellectual property laws or TRIPS. And so they were sort of trying to kind of resolve the ambiguity unilaterally. So another form of unilateral trumping, so to speak. So how do we resolve these conflicts? Well, that's a hard question, but the entity that's most likely to do it is a new intergovernmental organization known as the governing body, which will commence operations once the treaty enters into force. And I'll conclude by just very briefly IDing 3 of the hot-button political issues that I think the governing body is going to confront in its first few years of operation. Well, the first hot-button issue is drafting what are known as material transfer agreements. Those who are going to receive plant genetic resources from the multilateral system have to agree to certain conditions and limitations. But the terms of those agreements have, with respect to the treaty, have not been finalized. And key issues remain, such as the scope of IPR protection for derivatives and what commercialization actually is and how much needs to be contributed to the treaty's benefit-sharing trust account. Very big issues that are still unsettled. Another question is, do we expand this global genetic commons? Do we expand it to cover other food and feed crops? I mentioned earlier there's only a selection of food and feed crops incorporated. Well, why was that? Well, individual governments, mostly biodiversity-rich states, said, no, we don't want to contribute certain types of genetic material for food and agriculture to the system, because if we do that, we won't be able to reap unilateral gains through bioprospecting contracts and national access laws. So I think whether the multilateral system becomes robust and gets expanded, and the access principle is robust in this context, depends on whether there actually are tangible financial benefits from the treaty's funding mechanism, and that remains to be seen. So the third and final issue is with respect to private parties and their relationship to these multilateral system. Again, the multilateral system is just the material in international seed banks and in those materials controlled by governments. Now, private parties are encouraged to contribute their seed collections to the communal pot. Private parties such as universities, botanic gardens, and plant breeders. Well, why would they do that? Well, it's possible the governing body has the authority to decide to limit their access to the multilateral system if they don't contribute at some point in the future. So that's going to be a key carrot and stick issue. And so I think that could be the kind of incentive that might lead to a fear of hampering research and breeding work that would allow for the inclusion of private collections. So each of these three open issues remains contentious, and the treaty is, I would say, a work in progress about the public domain, and the hard implementation issues remain open. So I'm not clear whether it will be the case that governments do indeed will maintain the desire to cooperate to preserve the global plant genetic commons and the genetic diversity on which the world has come to depend. Thanks.
Okay, questions?
So my question is for Bob. You mentioned that you're skeptical that there's a lot of benefit being generated for developing countries by the intellectual property rights regime for plant varieties. But can I just push you to go a little bit farther? I mean, do you think that this is generating a large net welfare loss? And to give us a point of comparison, right? Which is worse for these countries? The current regime of intellectual property rights for plant varieties, or widespread trade restrictions on agricultural goods practiced by many developed countries? If we really wanted to help these countries, where would we want to focus our initial efforts?
Go ahead. Should I take questions or should I?
Why don't we collect a couple?
Let's collect a couple questions.
First, a comment. I'm very pleased that the copyright issue got brought up. I think it's an extremely important one, and I think it could easily be the right focus for any kind of academic network, because we really don't understand the issues yet. We don't understand the interests. There aren't the NGOs. It's the right kind of thing for academic thinking. But then Suzanne Scotchman, on her way out with an apology, dropped a question in my lap, and I fear it goes back to patents. And I think it's a very good question because it's been one in the back of my mind. And she is arguing in this question that, Richard, you and I are saying opposite things. That in essence, I would patent the laser as a significant invention. It would not patent some of the more obvious applications. You would leave the laser in the public domain because it's a research tool and would patent the applications. And I think there's a very important issue in there, and I'd love to hear your thoughts about it.
Marty?
Oh, I have a very specific question for Larry that is probably just directed towards him, which is, it strikes me that the two bracketed parts are directly at war with each other, and I can't imagine that there's how you could interpret them coherently. So that's just a point,
Okay.
because
He
in
probably
the form
can't either,
received
so.
suggests that you could interpret that to mean that you make any change whatsoever and you can patent whatever you want. So it's, I think it's absurd, basically.
We'll take that as a comment. Rochelle?
Rosemary.
Rosemary, sorry.
I was just going to ask another direct question to Larry, which has to do with the distribution of benefits and what the normative basis for the distribution of those benefits is going to be, because I think the normative basis and the legal basis might be at odds if you look across the various international treaties that govern.
Right? I think, yeah, and then I may have a question. Do you want to go ahead?
Yes, let me just, first on the question of TRIPS and its effects on developing countries. Basically, without R&D in your producing sector, in industry, the maximum growth that we observe among all those countries is 1.9% per year. That's maximum. I don't think you can actually grow any faster than that unless you have R&D. TRIPS can probably spread and diffuse the incentive structure for R&D, even inadvertently, even though it is, as I say, a mother country. It's driven by mother country interests and so forth. Do I think there can be losses? The losses are for those Group 1 countries, and they're not really losses so much from a lot of it comes from the Green Revolution. Those countries have been delivered falling prices for 40 years and no falling costs. And they are really victimized in many ways by that problem. Whether that's intellectual property driven, no, it's mostly driven by essentially the public agencies, the research centers that did the thing. The trade restrictions in the Doha round, yes, the Doha round is in serious difficulty because of the 2002 Farm Bill in the U.S. and the cap in Europe. The Doha round is supposed to deliver something to developing countries. You can't deliver much in the presence of cap and in the presence of the 2002 Farm Bill because you simply can't open your markets to developing countries, and if these countries have anything other than oil and diamonds to sell, it's food, it's grains and so forth. So, and finally on this international undertaking, I would say that's actually quite a remarkable agreement, and in fact, John has contributed a great deal to it. It's actually a remarkable agreement that actually resolved some very serious considerations and so forth. The farmers' rights from the Convention on Biodiversity are at war with conventional intellectual property rights. And this is at least a mechanism by which international agreements have been able to keep these intellectual property rights from stealing and encroaching on the commons.
Do you want to comment? And the laser point.
Yeah. Things like the laser give my point of view a lot of trouble, as do things like the explicit development of techniques associated with recombinant DNA, and that they're quite precise developments which can be associated with a small group of people whose use is, however, to a considerable extent upstream from final product use, and I see no way that I'm going to be able to tweak patent law to foreclose patenting of things like that. But I would like to see some mechanism that essentially opens use or assures use of broadly useful technologies of that sort for a fee in the further advancing of technology. I think the case is a lot clearer in terms of the kinds of things that disturb me in the, for example, the case of CellPro that Bob has written, where a patent was given on something that was quite some distance away from anything in the way of a practical application, and indeed was defined very, very broadly indeed. I think I have a much better idea about what should be done. But for things like the laser, I'd go in the direction of Rochelle type of Rochelle Dreyfus's type of research exemption.
That's a very popular view at Duke, particularly about lasers, I think.
I wanted to say something about the question directed at Bob. You know, the international trade regime and the negotiating power between developed and developing countries is really complicated from a historical perspective. This whole issue of agriculture and textiles has been on the table probably since the Kennedy round. I mean, this is not a recent thing, and I don't think that developing countries are in the near future going to have open markets in the developed world. This is, you may get incremental openings, you may get some sort of concession, but in the area where their comparative advantage is the greatest, this is not politically, from the developed country perspective, not feasible. And this is a fundamental, I think, imbalance from a trade perspective, just from the principle of comparative advantage, from a negotiating perspective. You keep getting little incremental windows, but they're not doing much by way of generating the kinds of revenue that would make the difference. And I think that Bob's response reflected that. The other point that I wanted to make, both about Larry's, and Larry will probably pick this up as well, is that this is where I think copyright and patent law intersect in some very unclear ways, at least in my mind. The protection of traditional knowledge, which I know there's a whole panel on tomorrow, when we talk about protecting the commons, there's going to be some tension between the current proposals on the table about traditional knowledge protection, the sustainability of plant genetic resources, and the Convention on Biological Diversity. And that's a two-edged sword, or perhaps more than two edges. A sort of sword only has two edges. But the point is that's a multifaceted, complex issue that in terms of the normative distributional value of the undertaking, as well as the protection on the human rights side, as well as the proprietary issues, I don't think we have even really begun to scratch the surface as to whether there's a cohesive, comprehensive response that will deal with the allocation and the distributional effects.
And I'll just respond to Artie and Rosemary's point. I mean, Artie, I agree with you. I think it's incompatible, and I think the two clauses were meant to serve very different purposes. The or genetic parts or components was an attempt by anti-patent NGOs using developing governments sort of as their front to kind of claw back on patents over life forms. The in the form language was designed to sort of deal with abuses of patents from materials that have been taken from international gene banks. So I think the two are at cross purposes, and they are at war, and I think it raises a really hard issue of treaty construction when you have clauses that you can't necessarily read one without obliterating the meaning of the other, and state practice doesn't really help you make what is ultimately going to then be a political decision about which clause do you favor. My only thought there is that really what the PGR Treaty is about is allowing derivative products to be commercialized so that money flows back into the system. So if you're really preventing that from happening by having a sort of robust definition of in the form, then the whole treaty's purpose is subverted. So I think then both for political reasons and for that reason, we're going to end up with allowing for components to have some sort of protection. With respect to Rosemary, your point, I think the key issue is who gets the benefits of benefit sharing, right? That's the real normative question. And the only thing I'd say about that is it states, right, or is it farmers' rights? And after we talked, I looked back at the treaty to see, do the farmers get it or do the states get it? And the answer is sort of both, but there isn't clear how the money gets from, the FAO in Rome down to the farmers on the soil in the developing countries, although the states have committed to do that. So I think the normative heritage of this new treaty is grounded in
genetic agricultural diversity is created by women whose rights to that land that they till is negligible.
Yeah.
Jerome?
I want to thank the panel very much, and I want to apologize for Paul. I want to apologize for Paul Uhlir, who could not be here because of overriding family obligation. He was going to talk to you about this paper that Jamie mentioned and the work we've done in conjunction with what Dick Nelson has been talking about. We have an article coming out called Contractually Reconstructed Research Commons for Scientific Data in a Highly Protectionist Intellectual Property Environment. It maps the public domain for scientific data. It tries to show what the opportunities, what it has done, and what the opportunities will be. And it shows that the pressures on it are insurmountable. And the thesis it takes is that the only hope is for science to take charge of its data and recreate this scientific data in very detailed, concrete, contractual ways, building on Creative Commons techniques, building on open source techniques, and at the same time using techniques that would not discourage commercialization, but would not allow the commercializers to dictate the uses for scientific purposes. We have had quite a good reception in Europe on it. UNESCO, precisely because they are now suffering the effects of the database directive, and we hope that it will have some interest here. We regret that it's not quite out, but it will be out in Jamie's.
The volume will be out in 3 weeks and should be circulating to a number of people here. We'll try and circulate it to people at the
and the
people at the
title of the
conference.
volume will be
The title is, it's a Law and Contemporary Problems volume, but it's the Symposium of the Papers from the Public Domain.
from last November's conference. Thank you very much. And we will recess now for a break. I think the suggestion has been made that we have our discussion of the web of influence at lunch, over box lunch tomorrow, rather than later, so more people can participate. Is that agreeable to everybody?
Yes,
Well, we were going to have the discussion of the academic web of influence from 2 to 3:30 tomorrow. And suggestion is made that since there's a box lunch at 1 o'clock, we just discuss it over that box lunch, so more people can participate. If that's agreeable, that's what we will do. Okay. Thank you. Thank you for the suggestion.
What plane are you taking back?